If I don't, I can take my mask off. It was smarter.
You're just being surprised.
Right. Thank you everyone for coming to the 15th annual Evil Twin Debate, brought to you by the University of Richmond in conjunction with St. Louis University School of Law and University of Missouri School of Law, and of course WIPIP. Thanks for being here. I'm Jim Dixon on the University of Richmond faculty, although this year's Evil Twin Debate is going to be my colleague Kristen Osenga. He's going to handle the Q&A and the black handing at the end, but I don't think he trusts me to run the camera, so we actually need to do the introduction. So the Evil Twin Debate series is founded on the notion that experts in IP law are often sort of loggerheads about important issues about IP policy, but remain very friendly on a personal level. And so the series seeks to bring together professional scholars who can disagree on an important topic, but who can air the disagreement in a friendly way, sort of serious in substance, but lighthearted in tone. Our debate topic today is efficient infringement, awful or awesome, focused on whether some types of patent infringement are actually net benefits to society. Our equal twins today are Jorge Contreras from the University of Utah College of Law and Richmond School of Law, Kristen Osenga. George will get 15 minutes to set the issue up and present his argument, and Kristen will get 18 minutes in response, and then George will get 3 minutes in rebuttal, and then we'll open up the remaining time for questions. One of the traditions at the Evil Twin Debate is rather than asking each participant to submit a bio, as is usually the case when we're doing these sorts of things, we ask each participant to submit the other's bio. And so now I will read the bios. Kristen's bio of her evil twin, Jorge Contreras. Kristen is delighted to introduce you to her friend and evil twin, Jorge Contreras. She thinks that what she enjoys most about their friendship is summed up by this possibly apocryphal story of how she met him. At an IPSC conference many moons ago, in a nearly empty room, because hey, the panel was up against a panel with Mark Levy on one side and one about Lowell cats on the other, Kristen dipped her toe into the Wild West of standard-setting organizations, and why patents are amazing. After she finished her presentation, George raised his hand, gave his typical friendly smile, and said, "So I think you may be thinking about this the wrong way." And so it has been ever since. In all seriousness, George is incredibly smart about so many different topics, and at one time, Kristen harbored a secret desire to write an opposing paper to everything that George wrote, but he's so prolific and has such a breadth of knowledge that she was having a hard time keeping up. Most recently, George wrote a book, an amazing book, upping the ante, a book on genes no less. The book has been highly reviewed and regarded by pretty much everyone, so Kristen decided to compete with him by running really long marathons instead. Since he was unaware of this aspect of the competition, although when we read his bio, it turns out it's not, she thinks she's beating him pretty handily so far. Lest you think that George and Kristen disagree about everything, she wants to conclude by telling you two things about which they do agree. First, George takes the most amazing pictures of Utah and elsewhere. She's jealous of this, but he's kind enough to share the photos, and Kristen can tell you that he loves nature as much as she does. And finally, and possibly most obscurely, George and Kristen share a deep love of coffee, both admit to owning 2 main coffee-making devices, and both of them may have been the last 2 people on this planet to be using Starbucks original coffee maker. Kristen's looking forward to the discussion tonight, so George and she can pick right up where their friendship started. So here is George's bio of his evil twin, Kristen. Professor Kristen Osenga teaches intellectual property law at the University of Richmond School of Law, where she is the Austin E. Owen Research Scholar, a distinction that she earned due to her unflagging advocacy on behalf of those who own things. You can see where this is headed. To that end, Professor Osenga is well known in the legal academy as a champion of strong property rights, particularly with regard to patented inventions and the entities that frequently assert them, some of which are believed to dwell under bridges and occasionally need a roasted hobbit. Professor Osenga deploys a range of analytical research methods in her work, including in-depth consideration of historical sources. This approach is aptly reflected in several articles such as Space-Age Medicine, Stone Age Government, How Medicare Reimbursement of Telemedicine Services is Depriving the Elderly of Quality Medical Treatment. And Rembrandt's and Research Lab why universities should take a lesson from big business to increase innovation. This commitment to historical evidence is further evidenced by the strong resemblance between Professor Osenga's Facebook profile picture, and the possibly copyrighted image of the Nordic shield maker Lagertha, who was recently featured in the History Channel's televised series Vikings. In addition to her penchant for axe throwing, Professor Osenga and Lagertha share an interest in reforming the inaccurate historical depiction of Vikings as blood-thirsty rapacious warriors to reflect recent archaeological findings that reveal that these misunderstood figures were, in fact, bloodthirsty rapacious warriors who ate lots of fish. Outside the classroom, Professor Osenga is an accomplished runner who successfully competed several marathons. competitive spirit, but also the legal analysis as demonstrated by tracking field-inspired titles such as "We Must Win the Race to 5G" and "US Takes One Step Forward, Two Steps Back on Innovation." But the true intellectual virtuosity of Kristen Osenga's scholarship is best exemplified by her capacious 2007 synthesis of entomology, the Second Amendment, and patent law in ants, elephant guns, and statutory subject matter. A tour de force of statutory exegesis and metaphorical lettering. With these forensic tools at her disposal, along with a few well-aimed throwing axes, Professor Osenga should prove to be a formidable contender in today's evil twin debate. And with that, I'm going to give George his initial 15 minutes. Welcome, George Contreras. All right. Thank you. So the subject of this evening's debate, efficient infringement, awful or awesome, refers to a trending narrative that casts any opposition to the demands of patent holders as a form of lawlessness. This narrative specifically takes aim at a practice that has been termed efficient infringement. The idea that a firm may rationally decide to infringe patents either because it will be too costly for the patent holder to enforce its rights in court, or because it is happy to take its chances in court, or an asserted patent may be invalidated or rendered unenforceable for a variety of reasons, and where damages eventually assessed against the infringer years later will likely be no higher than the royalties that the infringer would have paid anyway under the licensing agreement originally proposed by the patent holder. Opponents bemoan a prevailing steal what you want attitude among large companies. One commentator explains that efficient infringement is another way to say it's okay to violate a constitutionally granted right. Another compares patent infringement to piracy on the high seas, arguing that infringers exploit the lack of enforcement of the law of nations. One conspiracy-oriented writer, just days after the 2020 U.S. presidential election, was quick to blame the, quote, enemy within for the anti-patent chaos that marked large portions of the Obama administration. Who was this enemy? Apparently, it is a handful of politically well-connected companies that were helpful to Obama's own political ascendancy. Among the top recipients of criticism from this work is the Patent Trial and Appeal Board, the PTAB, an arm of the Patent and Trademark Office that has rejected a large number of issued patents as invalid. As a result, the PTAB has been called a patent death squad and a kangaroo court, despite the fact that, at least to my knowledge, it has consistently operated within the statutory mandate established by Congress. Unfortunately, these extreme statements cannot be written off as the intemperate musings of conspiracy theorists, internet trolls, and anti-vaxxers. They have been made by respected figures in the patent world, former government officials and judges, academics at well-regarded institutions, and proliferators on patent doctrine and litigation. But are they right? Is the United States descending into a state of patent anarchy characterized by so-called efficient infringement? I submit that it is not. To refute the arguments against efficient infringement, or rather, the resistance to immediate capitulation that patent holder demands, let's consider more closely the conduct that critics decry. When complaints about efficient infringement are made, they're generally not referring to cases in which one company copies its competitor's patented products and hopes to get away with it. Nor do they refer to cases in which breakthrough discoveries are made and jealous competitors race to incorporate them into their products. Nor is this a case of a licensing deal gone sour, in which one company reneges on its obligation to pay the agreed price for access to its partner's technology. Finally, these are not cases of industrial espionage, in which valuable technology is surreptitiously pilfered from a competitor's servers or carried away by disloyal employees. Conduct such as this is indeed lawless and worthy of condemnation. But the scenario in which efficient infringement is generally identified is different. Here, a large operating company, often a manufacturer or service provider, is approached by a patent assertion entity cup in hand. This PAE notifies the company of a patent portfolio in the general area of the company's business. It offers a fee-bearing license to the company, but the company largely ignores the offer, the message back to the PAE is sue me, because that's the only way I'll ever pay you a cent. Why would a law-abiding company adopt this approach? Is it evidence of the lawlessness the critics decry? I don't think so. In fact, there are several legitimate business reasons that a company should adopt precisely this approach when confronted by a PAE demand. First, it is worth noting that PAE assertions have increased markedly over the last 2 decades. In the early 2000s, PAE suits represented only 15% of patent litigation. In 2019, PAEs initiated 58% of patent infringement suits, and by 2021, 87% of patent suits in the high-tech sector were initiated by PAEs. Second, every year, a significant number of patents are found invalid, either at the PTAB or in court. Depending on the industry, this invalidation percentage can be well over 50%. Thus, when a company is approached by an entity bearing patents, there are good odds that some or all of the proffered patents will be found invalid. Compounding this fact, patents held by PAEs are often considered to be of lower quality than average. Why? Because they're often acquired from bankrupt firms who do not succeed in the market, or are slumped out by successful firms that do not find it particularly useful for their businesses. If these patents happen to cover a company's products, it is often a coincidence or the result of broad and aggressive claim drafting by patent attorneys. This last point is worth spending a moment on. It is undeniable that the claims of many asserted patents, especially in the software industry, are vague and ambiguous. Patent claims do not protect circuit diagrams or computer code. Rather, they are linguistic constructs crafted by lawyers to be as broad and encompassing as possible. Often, they do not even describe how a particular technology works, but only what its end function is, the practice of, quote, functional claiming that Mark Lemley and others have previously pointed out. I submit that those who analogize patent claims to real property deeds have not read enough patent claims. There are no clearly drawn boundary lines here. Instead, the descriptions of inventions harken back to the worst of the meets and bounds systems of yesteryear, in which property lines were established by descriptors like a stone's throw from the river, or where the old church used to stand. So the question of whether a particular product in the real world infringes a patent claim crafted by someone, perhaps years earlier, who was not even aware of the allegedly infringing product is a fraught one. Often, there's no clear answer to this question until the judicial claim interpretation hearing, and even then, a sizable amount of uncertainty remains. This indeterminacy is compounded by the behavior of PAEs themselves. Often, a PAE demand letter will refer to a portfolio of patents with no clear linkage to the recipient's products. In patent litigation, we refer to a claim chart that identifies how every element of a patent claim is practiced by an allegedly infringing product. Claim charts are often missing from PAE demands. This omission is understandable. Many PAE litigation campaigns target dozens or hundreds of different companies and products. So a detailed mapping of asserted claims to allegedly infringing products is impractical. Thus, it is often only through litigation that a patent presented by a PAE can be assessed and valued definitively. So it is not at all irrational for a company that's approached by a PAE with a stack of patents of dubious validity where infringement is uncertain to ignore the approach and allow litigation to produce a definitive result. This is, in fact, an entirely rational strategy and wholly in keeping with the law as it stands today. There is no element of lawlessness in the law. In fact, challenging potentially invalid patents, clearing them from the field, has been found by the Supreme Court to be a significant public service. Since Lear versus Atkins in 1969, the court has recognized, quote, the important public interest in permitting full and free competition and the use of ideas which are in reality a part of the public domain. So, critics, however, also complain about the systemic features that enable operating companies to adopt the wait and sue approach that I've described. For example, critics of efficient infringement object vehemently to the PTAB's propensity to invalidate patent claims after they have been allowed by the PTO. No matter if the PTAB is part of the PTO, this administrative body has been unsuccessfully challenged on constitutional and administrative grounds for years, and the challenges continue. Why? because the PTAB takes a more skeptical view of patent claims than the PTO examiner for, which is, as others have pointed out, compensated based on the number of applications processed rather than the quality of their output. Another frequent target of these critics is the Supreme Court, whose quartet of patent eligibility decisions, Bilski, Mayo, Uriah, and Alice, have been roundly criticized for rejecting the patentability of laws of nature, naturally occurring products, and mental processes. Allegations have been made that the Supreme Court is itself acting the laws, or at least in ultra-virus manner, by creating judicial exceptions to the statutory enactments of the Patent Act, a function that the court has pursued for the past 2 centuries. Something else that critics of so-called efficient infringement seem to forget is the ability of the district court to enhance damages awards up to 3 times if the infringer has acted willfully. Lex Machina reports in 2020, enhanced damages were awarded in 20% of patent cases, that resulted in a damages award, yielding a total of more than $1.6 billion in enhanced damages, compared to total reasonable royalty damages of about $3 billion. These statistics demonstrate that the threat of enhanced damages is a real one, and one that can and should deter willful, efficient infringement. In the end, I acknowledge that reasonable people can differ over optimal patent scope and policy. Likewise, the PTO and the PTAB can issue and uphold more or fewer patents, and the courts can interpret the Patent Act in ways that we like or dislike. Reasonable people can also seek change through litigation, legislation, and administrative channels. All of these mechanisms are organic parts of our tripartite system of government. We will never have a system in which all party signatures are equally happy with the rules or the outcome of every case. This is part and parcel of an adversarial legal system, but this is no reason to question the legitimacy of the system itself. So far from a departure from the rules of law, what we see today in the patent system is the operation of a well-functioning legal mechanism seeking to address the interests of competing but largely law-abiding stakeholders. So in response to the allegation of efficient infringement, I say, awesome.
I say awful. So let me just start by saying I have a paper coming out where every time I refer to this behavior that George references, I call it efficient infringement with scare quotes. And so I'll try not to scare quotes too much today, at least not excessively. So just to start with first, before I even get to my remarks, George might now have been the only person beside my mother to access my student note. So thank you. I really truly appreciate the work you went into that something so old. Okay, anyway, so let's get back to efficient infringement. So I'm going to give 2 main frames for my remarks, and in going through my frames, I will touch on some of the things that George said, and he's heard me say before, that's why we're here today. First of all, the name is just wrong. The name efficient infringement is a terrible name, and the problem with it, besides the fact that it's a terrible name, is it's ruining the policy discussions, and it's misleading people. And second of all, some of the justifications, some of which you heard from George, and some of the other justifications that people give for efficient infringement, I like to call them lies we tell ourselves to make bad stuff okay. Those are also wrong. So efficient infringement is obviously much more attractive when the likelihood that the infringer will be eventually joined is very, very low. So when we think about efficient infringement, we certainly think about patent trolls, as George mentioned, and we also think about standard essential patents. Okay, for very different reasons, in both of those cases, we are unlikely to see injunctions, and that makes efficient infringement incredibly attractive because you might as well infringe now, pay later. This is good. I don't like this wait and sue thing. I like infringe now, pay later. That's much better. Okay, so to understand why the name is wrong, I'm going to take a different way to think about efficient infringement, and we're going to talk about a supermarket being built behind my house. And they would like to use my yard for their parking lot. And so they come to me and they say, hey, can we have some of your yard for our parking lot? And I said, you could pay me for it. And they say, no, that's okay, thanks. And I wake up the next morning and my backyard is paved. That's efficient infringement. Right? This is the Big Bad Company, Publix. That's who that's super behind that. Anyway, they did not actually take, that's just a story. They did not take my backyard, but you can imagine this happening, and that's what a fish infringement should feel like. We would be outraged, right? You would be outraged, I would be outraged. If they paved my backyard after I said, pay me a license, and they say, no, I'm just gonna pave it anyway. Now, maybe the property lines aren't super clear, right? Maybe that's, we're not talking about encroachment, okay? Property professors out there, right? Efficient infringement is not encroachment where we're just like taking a little 2 inches of your property. No, they're paving the whole backyard. And that's not good, it's not nice, okay? Also, sometimes they do without even asking. They just take it, right? They don't even come for a license and then disagree if they just move on. So that's not what we would call efficient in any other circumstance, like the backyard being paved. It would just be predatory. So I'm actually making a push in writing and here and everywhere that we should rename efficient infringement as predatory infringement because it's more apt, it's accurate, and that's what we should call it. And the reason that's important is this, okay? If we rename it predatory infringement, it would make our policy discussions a lot better because folks, especially those who don't understand and/or like patents, hear efficient infringement and hear George being very persuasive, and they think it's a good thing. Okay? I mean, who doesn't want to be more efficient? I wish I was more efficient. But taking the idea of using the word efficient infringement doesn't take into account the harm that is being done to the patent owner. Okay? Now, this term, efficient infringement, kind of dates back to 1998. It might go back further, but anyway, in general, most law review articles even say that it goes back to a student note from 1998 by Julie Turner. And it's all about the non-manufacturing patent owner, not necessarily patent troll. Right? Just pay. If I am not making this particular patent, then it's better for them to efficiently infringe and go ahead and use it. From 1998 forward, every time there's talk of efficient infringement, very little shrift is given to what the patent owner is losing. Okay? And George told you, I like owners. So not since then, not when it was brought up, not now, nobody's actually talking about what is lost by the patent owner. It's not actually efficient. Okay? Efficiency would ideally mean that there's some benefits from both sides of the equation. It's not. There's a windfall for the infringers and a significant potential loss for patent owners. Okay? The patent owner is losing the one thing that we get from patents, which is the right to exclude. We got nothing else. Okay? So it's a little perverse to say, okay, you're a patent owner, and the only thing that you have is the right to exclude, and now there's a bad guy doing something, and a court has found it, and they're not going to give you an injunction. They're taking away the very right that patents give. Now, on the other side of the equation, we have a bad guy. He's an infringer, right? Where else in IP law do we reward the bad guy? That's actually a rhetorical question, because as I was writing this up and thinking about it, I'm like, oh, there's probably areas of IP where we reward the bad guy that I'm not thinking about. But anyway, let's just assume right now. Essentially, in this case, the bad guy, the efficient infringer, right, is getting an interest-free loan. Okay? Infringe now, pay later. And if he's lucky, and George was very effective at like ducking and weaving during his presentation this afternoon about some of this, he may have even done that little. Anyway, if the infringer is lucky, the royalty rate he gets given by the court after being found to infringe this ongoing royalty or compulsory license, whatever you want to call it, okay, may actually be lower than the amount that you could have gotten if he had negotiated a license as ante. So this is like a win-win-win. I get to infringe now and not pay, and when I do have to pay later, it's going to be less, and the patent owner is the person who uses in all of this, and that's us. So, predatory infringement. So, the two particular groups that don't get injunctions, which are going to be the groups for which we're going to see predatory infringement, I'll put that in efficient infringement. And patent trolls as the owners. So why don't patent trolls get injunctions? It's not because of what George said. Patent trolls don't get injunctions because people don't like patent trolls. Because they have lost out on that narrative a long time ago, and they're just bad, and everybody knows it. And I have written lots of articles saying why they're good, because neither here nor there, right? But they don't hide under bridges, they don't jump out to surprise unwary travelers, and they don't wield bad patents like swords. No. So when we're telling ourselves, okay, let's not enjoy those people, which sets up the situation for efficient infringement, what we're really saying is we're not committing to no light. Okay, so anyway, so right? When you're reading these, no injunction was issued against this person because they're a patent licensing firm cases. What you see is the court saying that the patent licensing firm has an extensive portfolio and licensing practice. They're not hiding. If they're hiding in plain sight. Sure as heck not hiding under a bridge because they have this huge licensing practice, huge licensing portfolio, and the court is using that as a good reason not to issue the injunction. But if there's really a big licensing program happening here, how is it happening under a bridge? It's not, right? So they're not hiding under the bridges. They're not often jumping out to surprise unwary travelers. Again, if you start reading through some of these cases, what you see is cases of failed negotiations. Not in all cases, but in a number of cases, what you see is that nobody's surprised because there was negotiations and they failed and then they infringed anyway. And then finally, with respect to them wielding bad patents, like swords. Here's the problem with that, right? We have colleagues, I think my English. We have colleagues, and I think it's my English, who have done studies about whether the patents that are asserted about patent goals are notorious or bad, and we found no, not so much. I'm going to trust my words because he really get his stuff. So if he says that they're not bad patents, they're not bad patents, so that's not a good reason. But even if they are really bad patents, even if they are unbearably vague, and they're not all software patents either, but even if they're unbearably vague, the point of it is that we have other ways to deal with it than just paying it over the backyard. And we have that PTAB, and also that PTAB is on a death squad, so wouldn't it be a really good idea to use that PTAB to get these things invalidated without just paying it over there? Rather than going to court, right? There seems to be a better way to invalidate these patents. And what we're really worried about, right? If we're really worried about why efficient infringement is so attractive to use it's always these bad patents, and we shouldn't have to pay licenses for bad patents. Well, then take them over to the PTAB, get the PTAB to that squad, and everything is good. Next, SEP owners. And this is my personal love here. And George didn't bring them up, and that's okay, because I know he doesn't like this either. Anyway, so why don't SEP owners get injunctions? And them not getting injunctions also sets us up for a place where we have efficient infringement. Because we don't like them, just like patent. Oh, and Fran. Okay, so here's the thing, right? For those of you who are not like deeply steeped in SEP stuff, let me just give you a little quick rundown of SEP ownerships and Fran. So we love standards. You love your 4G, you love your 5G, you love your USB, your Wi-Fi, you love all of those things. The way we get those is standard setting, okay? And when we get standard setting, we get a bunch of companies coming together, sitting in a room, doing technical things, because I got Sharon School syndrome and I just saw the bathroom. Anyway, so the bunch of companies come together, they submit technology, the engineers in the room talk about it, they decide the best way to solve the problems, they set the standards. The companies that contribute technology that can be considered for incorporation into the standard, in many standard setting organizations, they agree to a FRAND obligation. Meaning, if my technology is picked for incorporation into the standard, and I have patents on my technology, I agree to license that technology to anybody who wants to use the standard at a fair, reasonable, and non-discriminatory, anyway, fair, reasonable, and non-discriminatory way, okay? And so what the courts do is they say, hey, you agreed to license it, therefore you don't get an injunction. Okay, fine, but here's the problem, okay? This FRAND obligation only applies to the SEP owner, the patent owner. And so they are required, because of this obligation that they have made to a standard setting organization, they are required to negotiate in good faith. They have to go for a license. The party that wants to the party that wants to practice the standard has no such obligation to negotiate in good faith. And so oftentimes what we are seeing in the standard setting organization situation where SEP owners are not getting injunctions, and so setting up this idea for efficient infringement, is they just choose not to license at all. Okay? They know they have to. They know the patents that are declared essential. Again, nobody's surprised. Okay? Nobody's surprised. And yet, they say, you want too much money, or they don't even try. They don't negotiate in good faith. They become unwilling licensees, and so they just infringe. Okay? And so that's what we're seeing in these two cases. This is where efficient infringement is happening most often. I think that, George says a lot of really smart things about having those, I was going to disagree again, one more thing. Those 4 cases that the Supreme Court has done with 101, it's a tetralogy. Quartet makes it sound very sweet, sexy, and nice, but tetralogy makes it sound like cancer is. Anyway, so, okay, that was Anyway, so bottom line, efficient infringement is like letting a big company take over your backyard without paying you for it, and nobody's going to stop them. It's not about the patents, it's about the bad behavior, and I think that's why efficient infringement is predatory infringement, which is awful.
Remind me after the talk to recommend some excellent science fiction tetralogies. Actually, pretty soon. Yeah. So in response to this, I would say, this Blackstonian absolutist notion of the right to exclude is outdated. We do not believe this anymore. Notwithstanding what the Supreme Court has recently done in tables cases, the Supreme Court in eBay shows us that the right to exclude for a patent holder is not absolute. It's not even absolute for real property owners, and patents are property anyway, they're government entitlements, but that's a debate for another year. And so it's not absolute, so we shouldn't treat it as absolute. And I think it's wrong to analogize the patent franchise as something like a piece of real property. As far as SEPs and standards, the big difference here, of course, is the patent holders agreed to make their patents available to the whole industry to ensure the broad adoption of the standard. This is a trade-off. They are giving up rights so that their technology will be incorporated into a standard so that they will make a lot more money, because then the entire industry will be required to use the standard. This means, however, the quid pro quo for that is that you give up the right to stop manufacturers from making those standardized products in exchange for getting a royalty that is fair, reasonable, and non-discriminatory. And I would just point out that some of the standards that are wonderful that you find well from USB are totally royalty-free. Anyway, of course, parties don't agree on what flag means. Nobody's checking the royalty levels at the STOs. But a lot of patent holders who hold these essential patents have spread their portfolios around amongst an army of MPEs whose sole purpose is to extract revenue from the makers of standardized products. I have written extensively about better ways to do this. I don't think litigation is the way. I think that there should be some sort of arbitral resolution of these frank disputes in an open and transparent manner that would, I think, at least as far as standards of any patents, eliminate some of these problems. So, thanks.
Let me grab my mask.
Yes, I want to make sure everybody's above board. So I don't want to keep us from food or band. Where's Yvette? I want to make sure. So Yvette, where's Yvette? I heard her voice. No, I'll get back. Maybe she's doing with the band. She's working on her voice. So we're going to open up for questions a little bit, but we're not going to keep people too much from the food or the band. Are there any questions for our evil twins? I see. Sean, you want to fire away?
Yeah, so again, kind of thinking about it, the real property analogy may work, right? And thinking about adverse possession, right? And it works well when you kind of think about it in the non-practicing entity framework, right? If you believe in the labor theory kind of analogy. It works less with the SEP. I'd like to hear your comments. It seems to me that it's even worse in an adverse possession, right? Because I'm just taking the grant and you get nothing, right?
I assume that was very good of me, so. Okay, so yeah, you are like the 400th person to tell me that those two things don't work the same way. Every time I explain this story to people, they're just like, yeah, SEPs and trolls, two different things, different paper. you that the argument is a lot better with respect to the trolls for the real property. But I don't know that I don't see the real property extension with the SEPs. I mean, they're still patents, and so the arguments are different underlying and because of the France situation, but I don't think that necessarily the real property extension doesn't go to SEPs.
I guess my fundamental kind of question then is, do NPEs really promote the progress of science and useful arts? Not, then maybe efficient infringement is okay. If they do, then let's not let that happen, right?
It's the patents that promote the progress of science, not the patent owners. That would be my answer to you. So, NPE, I don't care who's holding it, it's the patents that are promoting it. So, but George would disagree with me, probably.
You gotta play your roles to equal twin. You gotta.
Yeah. So, I mean, look, I actually agree with Kristen. I mean, patents. Patents.
Whoa.
The Constitution says nothing about who owns the patents. Right? It's the same patent, and what you do with it after it's issued can be good or bad. It can be efficient or inefficient, beneficial or harmful to the market. I mean, I do think that a lot of NPE behavior is harmful to the market and not particularly productive. But I don't think there's a constitutional question there. I mean, I think the constitutional questions go much more to one-on-one and other things that we can continue to debate, at the buffet line. But anyway, put my mask back on.
Yes.
So, George, does your argument extend beyond PAE patent owners into other varieties of patent owners? And if so, I want to hear that too. So
this phenomenon, I mean, in theory, I think the argument is fine. We should invalidate, we should encourage invalidation of invalid patents, and Lear versus Atkins was not a PAE suit itself. But the argument today primarily comes up in that context, right? You've got manufacturing companies, competitors. You definitely you've got infringement, you've got willful infringement, but at least I haven't heard this efficient infringement argument come up. And it is true, a large company generally IBM gets approached by Cisco. Generally, they don't just totally ignore that other company the way they would ignore a PAE. And the reason that Cisco is getting hundreds of PAE suits all the time. And so I think analytically there's not a difference, but just in practical terms, I think there is a difference.
Any other questions? Yeah, sorry.
So we've heard a lot about the property analogy, the real property versus not the property analogy. I would be interested to hear your view of this debate through the lens of contract instead, because it seems to me that the law economics origins of efficient infringement rest in the work that was done in the 70s and 80s on efficient breach of the contracts and what effect that should have on the availability of remedies, whether it's equitable remedies or legal remedies. But if we're talking about this through the lens of a bargain for exchange, the bargain might be a consummated bargain available between counterparties or between the inventor on one hand and society on the other. Whoever the parties to the bargain are, does that change your view of whether remedies should be available?
Who are you?
I want to
I have nothing to say. Go ahead.
I have something to say. Go ahead. No, it doesn't. The parties doesn't change it in my mind at all. It's hard to make it a good analogy to efficient breach because it's hard to think about patents in the contract context. But I'm not going to answer that. I'm going to let George answer that part because that one sounds hard. So my answer to yours, does the parties matter? No. And George will take the rest.
I want to go back to the tetralogy question. No, look, this term, efficient infringement, I mean, this is it's just borrowed, right? But it's a bad borrowing. I forget what you call it, like evildoing or something, but I don't think that's good either. It's actually much more justified in the patent context to infringe when there's some doubt about validity and infringement. Right? With contracts, I don't know, I guess I teach property and patents, I don't teach contracts, but it seems much more cut and dry whether you're breaching the contract or not. Yeah, there may be some excuses, some changed circumstances or something that might excuse performance, but that's not what efficient breach is all about. Efficient breach of a contract isn't excused breach, right? It's intentional breach, knowing it. Whereas with patents, you really don't know. Right? You'll have the kind of opinion letter from a law firm that Karen Sandberg just talked about in the last session. But you might in good faith think, look, this PAE, they've come to my door 12 times before, always with invalid stuff, junk, it's vague, like we have no idea what this means, no plain terms. We're not gonna respond. And they are in much better faith, I think, than the efficient contract infringer. So like this is like super efficient action, or I don't know what you call it, a blessed.
I think it's a super duper.
I love super duper.
You like super duper? One more, because I think I heard some strums on a guitar. Is that probably? I'll let you do it round two if there's nobody else. Go ahead.
Okay, so patent rights and filing of an ANDA, efficient infringement? Kristen?
That whole thing is nonsense. This is probably my talk from the last session. We just totally excluded all those ANDA cases. It's not really infringement. It's just a statutory, mime show. It's all to that's all.
So you're pro ANDA.
Yeah.
I think this is the best way to probably end this because I agree with George.
We have to end it if you guys are no longer.
We are no longer. No, I don't see it as it's not paving my backyard. There's no ultimate harm at the end of the day, so I would say no.
Okay, well, thank you so much to our table twins. So that you have something to put in your office that everyone will look at and say, what the hell is that? We've got our evil twin placards here, so you can be reminded of your evilness if you... Thank you so much and since Yvette's not here, I'll say everybody go to the other room and pick up an instrument.